Before we begin, I'd like to thank Julia Noon, our special projects editor, for coordinating this event. She was in charge of the food, the flight, the poster outside, reserving the room. She made this happen. So special thanks to you, Julia Noon, and the rest of our executive board. I see that Virginia Frazier, our executive editor, is here, and a couple of others will be here later. I think a few have classes right now. But our lady of the hour is Elizabeth S. Westfall. For some reason, I printed out her bio in 10-point font, so bear with me. My eyes aren't the greatest. Elizabeth S. Westfall joined Advancement Project as a senior attorney after 7 years as a civil rights litigator at the law firm of Relman and Associates and the Fair Housing Project of the Washington Lawyers Committee for Civil Rights and Urban Affairs. During her tenure at Relman and the Washington Lawyers Committee, Ms. Westfall represented numerous individuals and organizations in housing, employment, and public accommodation discrimination cases in federal court. In 2002, she co-chaired a public accommodation discrimination trial in Maryland's federal court in which the jury found that the defendant had discriminated against her clients on the basis of their race and awarded both compensatory and punitive damages. Prior to joining the committee, Ms. Westfall spent 2 years as an associate in the general litigation group of Wilmer, Cutler, and Pickering in Washington, D.C. Ms. Westfall received her law degree from Harvard Law School, where she served as editor-in-chief of the Harvard Women's Law Journal, and she received her undergraduate degree from Colleton College. Her hobbies include practicing the law and spending time with her 2 sons, Benjamin and Nathaniel. So without further ado, I'd like for you to join me in welcoming Elizabeth S. Westfall.
Thank you very much, James, for that lovely introduction. And I do want to thank the law school, and particularly Julia Noon and the Journal for organizing my trip here to speak to you all. I guess I'd like to begin my comments by first asking how many people are from the law school here, if you could raise your hand. Okay, good. Well, good. Most of you are from the law school. I am going to focus my remarks heavily on my article and case law in the area of what I will call maternal wall discrimination. Maternal wall discrimination occurs when women are discriminated against in the workplace because of their past, present, or future pregnancies, because they've taken a maternity leave or more than one maternity leave, or when they adopt either part-time or flexible work schedules. Although the glass ceiling and sexual harassment continue to pose formidable obstacles in the workplace for women, maternal wall discrimination is on the rise, and women are increasingly beginning to bring lawsuits to challenge such discrimination. There has recently developed quite a substantial body of case law under both the Equal Pay Act and Title VII, and which includes the Pregnancy Discrimination Act, in which plaintiffs who have brought maternal wall cases have prevailed. Joan Williams, who is my co-author in an article that will be published in the Journal in the spring here at Duke, and I wrote an article having reviewed hundreds of maternal wall and Pregnancy Discrimination Act and Equal Pay Act cases to review trends, recent cases that are favorable from the standpoint of plaintiffs, and also to try to figure out how to develop strategies to combat case law that is developing in an unfavorable direction in the area of maternal wall discrimination. First, the good news. There have been some wonderful, wonderful cases recently that are very helpful to plaintiffs who want to bring maternal wall type cases. They both have provided greater latitude to plaintiffs improving their cases under the Pregnancy Discrimination Act and Equal Pay Act, and they are also consistent with the social science research that describes how women are discriminated against in the workplace based on their status as mothers. 2 federal appellate courts in the 6th Circuit and the 8th Circuit recently held that the Pregnancy Discrimination Act applies to future pregnancies very broadly defined. In Kokak versus Community Health Partners of Ohio, the plaintiff in that case alleged that her former employer had rejected her application for reemployment due to complications that were related to scheduling caused by an earlier pregnancy that she had. The district court dismissed her case because she had not been pregnant at the time, nor had she had any medical conditions related to her pregnancy when the adverse employment action occurred. The 6th Circuit held that this was error and reversed, saying that indeed, based on the Supreme Court case Johnson Controls, that the Pregnancy Discrimination Act prohibits an employer from discriminating against a woman, quote unquote, because of her capacity to become pregnant. They also clarified that the first prong of the McDonnell-Douglas test, as it applies to proving a prima facie case of discrimination, only requires a woman to show that she was pregnant at some point in time and not necessarily at the time of the adverse employment action. Likewise, the Eighth Circuit in the Walsh versus National Computer case rejected the defendant's argument in that case that the judgment should be set aside in favor of the plaintiff because she had proceeded under a theory of parent discrimination, which is not covered by Title VII. The Eighth Circuit held that Ms. Walsh's claim that she had been discriminated against because, quote unquote, she had not because she was a new parent, but because she is a woman who had been pregnant, who had taken a maternity leave, and who might become pregnant again, unquote, was indeed a viable claim under the Pregnancy Discrimination Act. Both of these cases are incredibly important for several reasons. First of all, because it brings maternal wall discrimination within the purview of the Pregnancy Discrimination Act, much more broadly than it had been defined previously. It expands the classes of women protected by the Pregnancy Discrimination Act, thereby providing victims of maternal wall discrimination with an important avenue of legal recovery. These cases also align the coverage of the Pregnancy Discrimination Act with the findings of social science research documenting that there are in the workplace overwhelmingly negative stereotypes about both the competence and commitment of women who have been pregnant, who will be pregnant in the future, who have taken a maternity leave, who have adopted a part-time or flexible work arrangement. And these cases also hold the potential to protect non-mothers as well as mothers from maternal wall discrimination. Simply, that is, employers may view women who have not had children, that indeed they may have children in the future and that they are not desirable employees. Another important recent case in the area of maternal wall discrimination is the Lovell versus BB&T Solutions case that came out of the Eastern District of Virginia. That case was an Equal Pay Act case, and it held that the Equal Pay Act, quote, does not categorically preclude a part-time plaintiff from establishing a prima facie pay discrimination claim by designating a full-time comparator, and applied this same reasoning to her Title VII claim, the plaintiff's Title VII claim. The court also explained that where a plaintiff's actual duties, tasks, and responsibilities are essentially similar to that of the putative comparator, the question of whether a part-time employee could be compared to a full-time employee was a question of fact for the jury to resolve. This case is incredibly important for litigation of maternal wall cases from the standpoint of plaintiffs because it expands the type of evidence that plaintiffs with part-time schedules may use to litigate claims under either Title VII or the Equal Pay Act. Several decisions issued prior to the Lovell case had rejected the attempts of part-time plaintiffs to compare themselves with full-time employees. And indeed, as an empirical matter, in most workplaces, including the workplace in some of the cases that went the other way, there were no part-time comparators available for the plaintiff to rely on as evidence. There were no males who worked part-time, for example, and as a result, the plaintiff in those cases had difficulty proving her case with circumstantial evidence. The final positive and very groundbreaking case in the area of maternal wall litigation that has come out recently is the Back versus Hastings-on-the-Hudson school district case in the Second Circuit. In that case, the court held that stereotyping about the qualities of mothers is a form of gender discrimination for the purposes of the Equal Protection Clause, along the lines and similar to or the same as the stereotyping found to be direct evidence of discrimination in the Price Waterhouse case years ago by the Supreme Court. The plaintiff in Back, shortly after she returned from her maternity leave, was subject to a lot of discriminatory comments in the workplace. Her supervisor inquired, for example, how the plaintiff was, quote, planning on spacing her offspring, unquote, asked that the plaintiff not become pregnant until the supervisor retired, and suggested that the plaintiff wait until her son was in kindergarten to have another child. The district court, nevertheless, granted summary judgment in favor of defendants, but the Second Circuit reversed, holding that comments made about a woman's inability to combine work and motherhood and that a woman cannot be a good mother and have a job at the same time that requires long hours, constituted direct evidence of sex discrimination under stereotyping theory similar to that recognized by the Supreme Court in Price Waterhouse. The court further held that Ms. Back, the plaintiff, did not need to produce evidence about the school's treatment of male administrators with children. That is, she did not have to come up with comparative evidence because she was proceeding under a stereotyping theory. This case is incredibly important because it again acknowledges the presence of stereotypes in the workplace, that mothers are insufficiently committed to their jobs and thus cannot competently perform their job responsibilities, and that these views are indeed gender stereotypes and can be evidence, direct evidence, used in litigation that plaintiffs bring under Title VII and under the Equal Protection Clause. This case also offers plaintiffs flexibility in the type of evidence they present, and the court also held that a plaintiff need not bring expert testimony to say, yes, these stereotypes exist in the workplace. You simply need testimony from lay witnesses. And finally, that case is important, as I mentioned before, because if you proceed under that theory, the stereotyping theory, you need not present comparative evidence that fathers were subjected to dissimilar treatment in the workplace. So that's the good news. The bad news is that based on Professor Williams and my review of the case law, during the past 15 years, there has been a body of unfavorable case law that has developed under the Pregnancy Discrimination Act, because they're involving employers who took adverse actions against plaintiffs because they were temporarily unable to perform their job as a direct result of their pregnancy. For example, courts have dismissed cases in which the plaintiff's employment was terminated due to her absence from work caused by morning sickness. Other courts have dismissed claims brought by plaintiffs who became temporarily unable to lift heavy objects due to their pregnancy. Courts in these cases have set forth several grounds for dismissing these claims. I'm going to discuss the grounds, and then I'm going to suggest strategies for improving the development of the litigation in this area. First, courts have held that plaintiffs' inability to perform the required job functions, while concededly due to their pregnancy, is fatal to proving a prima facie case. That is, the plaintiff, if she is unable to lift a heavy object, then she's not quote-unquote qualified for the job, and she would fail under McDonnell-Douglas under the first prong of proving a prima facie case. Second, courts have seized upon plaintiffs' lack of comparative evidence that the employer granted more favorable treatment to non-pregnant employees who were tardy or absent from work, for example, or who were unable to lift heavy objects. And finally, courts have insisted and made the rhetorical point that the Pregnancy Discrimination Act does not require so-called quote-unquote preferential treatment, unquote, of pregnant women, and have argued that the statute serves as a, quote, shield against discrimination, not a sword in the hands of a pregnant employee. This has resulted in some rather remarkable language in the case law. Courts have affirmed the dismissal of Pregnancy Discrimination Act claims while at the same time rather forthrightly admitting that the plaintiffs were terminated due to their pregnancy symptoms, that is, due to their membership in the protected class. One court suggested that some degree, in fact, of inequitable treatment between pregnant women and their non-pregnant husbands is par for the course and not prohibited by the Pregnancy Discrimination Act. I would now like to turn to strategies for dealing with this rather unfavorable case law. First, I would suggest in bringing these type of cases involving either absences from work or inability to lift heavy objects or morning sickness, that plaintiffs should conduct their discovery designed first to identify direct evidence of discriminatory intent, including stereotypes related to the plaintiff's status as a pregnant woman. As I mentioned before, employers often in this environment are not careful about comments that they make in the workplace concerning mothers and related to pregnancy of their employees. Therefore, there may be direct evidence of discriminatory intent, and plaintiffs can avoid going through McDonnell-Douglas and circumstantial proof of discrimination. Second, If direct evidence is unavailable, plaintiffs who seek to prove their case circumstantially under the McDonnell-Douglas burden-shifting paradigm should argue for a flexible, reasonable prima facie standard. I would suggest that plaintiffs should argue to courts that the prima facie standard should ask whether the plaintiff is qualified for the alternative job or modified job responsibilities that she has requested, and whether she was qualified for the job she has previously held and would be qualified again once her pregnancy symptoms have passed. This standard has been argued and adopted in the 10th Circuit. Third, plaintiffs should thoroughly explore the employer's treatment of non-pregnant employees whom the employer purports are similarly situated to plaintiffs. If comparative evidence is unavailable, the plaintiff should gather evidence that shows that pregnant and non-pregnant employees whom the employer asserts it treated equally are not similar. For example, if the employer argues that it fired both pregnant and non-pregnant workers for tardiness, plaintiffs should attempt to discover, through the discovery process, differences between the plaintiff and the persons outside of the protected class, such as frequency or severity of the tardiness, performance problems of the non-pregnant employees, differences in the job responsibilities between non-pregnant employees that might make their physical presence in the office during fixed hours a requirement of their job, in contrast to the plaintiff's job. Finally, plaintiffs whose pregnancy symptoms render them temporarily unable to perform one or more of their job responsibilities should argue that they're entitled to present other circumstantial evidence that their employer discriminated against them on the basis of their pregnancy or quote-unquote related medical condition, as is set forth under the language of the Pregnancy Discrimination Act. Suppose the plaintiff is a lawyer whose employer ostensibly terminated her employment due to her tardiness that stemmed entirely from morning sickness, and the employer defends its decision by asserting that it has a policy of terminating employees, non-pregnant and pregnant alike, for tardiness. The plaintiff may wish to probe the genesis of the employer's policy on tardiness to determine whether the morning sickness-related tardiness of the plaintiff or other pregnant employees triggered the adoption of the policy, whether the alleged purpose of the policy is otherwise a pretext for discrimination, the history of the use of the policy and to whom the employer applied such policy, the job performance of all employees who the employer alleges it terminated for absenteeism, the employer's treatment of other pregnant employees, the representation of pregnant women and women generally in the employer's workforce, and the employer's policy with regard to pregnancy, maternity, and work-life balance. Hopefully, this discovery will bring about circumstantial evidence that will help the plaintiff show that she was terminated because of her pregnancy and representation and membership in a protected class and not for other reasons. I would also like to note at this point that although some courts assume that presence in the office is necessary and that termination of absent employees is fully warranted and not actionable under Title VII, plaintiffs may be able to generate evidence through their own testimony that their presence in the office during particular hours was, in fact, not necessary to the performance of their jobs. And finally, and I would like to conclude my remarks shortly, I would like to discuss generally the potential of Title VII to be used as an expanded remedy for mothers and other caretakers in the workplace. Many academic commentators have declared Title VII is all but dead and that it cannot be used as a means to combat maternal wall discrimination in the workplace. However, given the current political environment, it is unlikely that we are going to have federal legislation that expands protection for caregivers in the workplace. So I would argue that Title VII is not without potential to remove barriers to caretakers' participation in the workforce. The concept of pretext in the McDonnell-Douglas burden-shifting paradigm is one that is long familiar to the courts and may, in fact, provide a means for challenging workplace structures that unfairly disadvantage caretakers in the workplace. Under the third prong of the McDonnell-Douglas test, a plaintiff must show that the employer's purported legitimate reason for its adverse action against the plaintiff is a pretext for discrimination. Evidence in support of pretext may take many forms, including weaknesses, implausibilities, inconsistencies, incoherencies, and contradictions in the employer's proffered legitimate reasons for its action, that a reasonable fact finder could find that the reasons were unworthy of credence. Therefore, plaintiffs are entitled broad leeway in conducting discovery concerning pretext. Proving that an employer's purported non-discriminatory reasons for an adverse action is pretextual provides a plaintiff with an opportunity to expose that the employer's policy is false and illegitimate as applied to her and, by extension, other workers. For example, in defending their decision to terminate the employment of a pregnant worker, some employers assert that they merely applied a reasonable workplace rule, such as terminating, as I mentioned before, the workers who are tardy or absent. Through discovery, a plaintiff could explore the inappropriateness of applying this rule to her job, her ability to fulfill her job requirements without being physically present in the office, and the impact of this rule on women and other caretakers in the workplace. By exploring that the employer's reason for firing the worker was in fact pretextual, the plaintiff would result in challenging the assumption of many courts and employers that all employees, regardless of their particular job responsibilities, must conduct their work in the office during particularized, unvarying business hours, and that indeed that requirement is a legitimate non-discriminatory requirement. This approach, if successfully adopted by plaintiffs, could cause employers to review their absenteeism and tardiness policies to ensure that their application to pregnant employees and particular categories of jobs could withstand an attack for being a pretext for discrimination. Accordingly, these cases might undermine the workplace essentialism that disadvantages many caretakers in the workplace. And I would conclude by just noting in an optimistic note that discrimination at this point, although it is quite often transparent in the workplace, and there's quite often evidence of very forthright, open discrimination against caretakers in the workplace, litigation to combat such discrimination is on the rise. Courts are beginning to recognize it and frame it in a way that is more similar to the sexual harassment litigation and body of case law that has developed, and I believe will become will result in providing more legal relief for plaintiffs and improving the workplace for women on the whole. Thank you very much. James.
Does it seem to you that the law incentivizes rights for upper class and middle class women who have the financial resource to take time off from work? For instance, most upper class and middle class educated women have husbands or dual income households in which they can afford to take time off from work, but the law doesn't provide a remedy for women who have low income jobs or for single mothers who can't take the time off from work, although they're granted this time by law.
Well, I think your point is well taken. I certainly think the Family and Medical Leave Act is completely inadequate as a remedy, and it does result in, as a practical matter, for low-income women to be unable to take the time off. I do think certainly that plaintiffs who are generally people who are able to be plaintiffs, unless they're able to find contingency arrangements for representation in litigation, tend to be middle class to upper class people. So I certainly think that there does need to be legislative remedies. I just think, and changes and improvements to the FMLA. And I know in California, there's legislation that perhaps has been enacted that provides paid family and medical leave out of unemployment insurance to workers in that state. I do not foresee that happening at the federal level, unfortunately, in the near future. Yes?
If you could rewrite the Pregnancy Discrimination Act, what changes would you make to it?
That's an excellent question, and I definitely think you can see, unfortunately, that the Pregnancy Discrimination Act is obviously a product of compromise, and there are some tensions in some of the clauses. So I would not, if I could rewrite it, I would get rid of what I think was probably a compromise in the act that focuses on treating women the same as other workers, because indeed it creates, it limits the usefulness of the Pregnancy Discrimination Act if you focus on treatment with of the same treatment with other workers, because then the protection really, in effect, only extends to women who have no pregnancy symptoms whatsoever in the workplace. You need to be able to work uninterrupted without doctor's appointments, morning sickness, et cetera. Any inability to lift heavy objects, which is as a medical matter is not the case, for the entire 9 months. So I would rewrite that clause. I would take that out and simply leave the prohibition against discrimination on the basis of pregnancy and related medical conditions in the Act. Other questions?
How do you respond to people who suggest that maybe pregnant women shouldn't get any special treatment because of their condition? Like, I read one article actually by a woman, I think the University of Chicago, saying that as a woman, she doesn't want she doesn't want to take on the extra work that happens when one of her co-attorneys has to leave for a month or two, and that she doesn't want to have to pay the extra insurance money to cover the treatment, and that she's chosen not to have children because of that. And so how do you respond to people who make that kind of objection to any special treatment in the first place?
Well, certainly I think since we've decided as of 1964 that gender is a protected class under the Civil Rights Act, and even under the Constitution, it's deserving. When you classify things on the basis of gender, it's a suspect classification. So I would argue that pregnancy, as a legal matter, pregnancy and gender are very closely connected, and that it has to be a discrimination for which there is a remedy and some protection. As to your particular point, I think we have decided, certainly there are policy arguments as to why we should ensure that women, regardless of whether they're having a pregnancy or not, are able to work freely in the workplace in terms of maximizing their economic contributions to our society. And certainly we want to have a new generation born and raised and providing workers to support workers. Certainly the whole structure of how Social Security is financed relies upon a new generation of workers. So it's certainly from the standpoint of figuring out a way to encourage and allow all members of society, regardless of their parenting status, to participate to the fullest extent possible and make economic contributions within the workforce. I think there's a policy argument for it. I guess on the day-to-day, yes, certainly some people in the short term bear some costs in terms of working with people who take, for example, maternity leave, and their work needs to be covered.
Based on your survey of the case law, do you have any sort of rough idea as to how many of the women were how many of the mothers were single mothers who were discriminated against, and whether that influenced the kind of discrimination or things that were said to them in the workplace?
Well, certainly there is some really, I did not see a lot of case law in which the court made reference to that aspect of the plaintiff's status. I did see some rather remarkable cases in which status as a single parent was viewed by the employer very adversely, and adverse action was taken based on that, sort of tied in connection with, for example, having a child, quote unquote, out of wedlock and things of that nature. It was tied, the court would tie it together with concerns about pregnancy discrimination in general. But on the whole, the courts did not comment on the marital status of the plaintiff.
You've mentioned a couple of times that you don't see any federal action on this matter coming anytime soon, and I'm wondering how much you think that is a framing issue. That is, it strikes me that if I wanted to convince conservatives to go for this, I would frame this in terms of for example, abortion, right? It seems like protection for pregnant women is going to de-incentivize abortions, for example, rather than framing it as a discrimination issue. Why not frame it as something like a pro-life issue?
Well, I think that's a very interesting question, and I certainly didn't mean to suggest that there is not support from quote-unquote conservatives or Republicans or the right for these type of issues. In fact, Joan Williams has found a lot of support among those communities who are family-centered in protecting women in the workplace with regard to these issues. I certainly have not seen it cast as an abortion issue. I think there could be support from the conservative movement for this issue. I think as a practical matter, given the composition of Congress, there is not a likelihood that this Congress will be willing to or interested in imposing expanding Discrimination Act with, as it relates to burdens on employers. That was sort of my view on that.
This is sort of an odd, but have there been employers who have contracted with employees to sort of build in this family planning idea where you sort of set this sort of conditionality, like you're not going to have kids for the first 3 years, or and would such contracts be sort of voidable?
I think you just answered my comments or made my comments. I certainly think those contracts would be voidable. I've never heard of such contracts. I think there are a lot of, I sort of gather that there are a lot of informal, below the surface understandings between employers and their employees on timing of children. But certainly I've never heard of anything being actually within a contract. But that's an interesting idea. I think they probably would be voidable because I don't think you could limit someone's right to choose when they're going to have their family contractually. I don't think a court certainly wouldn't enforce that if there was a breach of contract action brought by the employer. I wouldn't think.
But don't some employers say, you'll get a certain amount of maternity leave after a year, after 2 years, and isn't that kind of a way of making people wait to have families?
Well, that's actually, people are definitely incentivized, and that's actually a specific requirement within the Family and Medical Leave Act, that you are not entitled to tap into the benefits, or not the benefits, but the right to take time off under the Family and Medical Leave Act unless you've been with the employer for a year. And the Family and Medical Leave Act is also limited because it only applies to employers that have over 50 employees. So certainly does create incentives for employees not to have children until they've been with an employer for a year. You're right.
To what extent has, say, the legal profession come under fire? Have any women challenged perpetually not getting partnerships, for instance, because they're having kids?
Yes. Yes.
And does this figure into this, sphere of case law?
Yes. Actually, there are some really interesting litigations that were brought in Connecticut by some women who were in-house counsel for an insurance company, and regretfully, I'm forgetting the name of the case. I'm sure it's in my article somewhere. Yes, definitely. I think they're the perfect plaintiffs. Unfortunately, I think in the legal profession generally, the billable hour is certainly an anvil over many, women's, workers, caregivers' heads. But there has been litigation in that area.
I'm a grad student in a different department here, so a lot of legal stuff's going over my head, but I have a lot of women's studies kinds of questions about what you're saying. How do you enforce this kind of litigation without creating a kind of biological essentialism? Because that's the big concern of feminists about this kind of law. Does it reinforce that women are wombs,
Well, I think that's a great question, and I'm not really sure what the answer is to that. I think that's one of the major criticisms of certainly one of my co-authors' articles and her thinking is that it does get into problems related to essentialism and whether women are wombs. I think the way you get around this is enforcing the legal rights of men and women who are doing primary caretaking and cast it more as a caretaking issue. Certainly not the biological aspects of pregnancy, but certainly the caretaking. And there may be, I haven't seen it, but there may be a case out there ready to be brought by a father who has been very involved in caretaking for a child who has, experienced perhaps some, withstood some comments in the workplace that could constitute direct evidence of gender stereotyping, and perhaps he would have an action under Title VII. I haven't seen it, but I think the way to get around the essentialism is to cast it as a caretaking parenting issue and not so much a issue related to and limited to women. At the same time, I think as a practical matter, if we proceed down the path of, assuming women don't ever have caretaking responsibilities, it sort of denies what is actually happening in marriages, in relationships, in what sociologists tell us about how children are cared for in this country, which is largely by women, largely by their moms.
You've already addressed this concern of, whether this impacts single mothers more harshly, but as to women who have not yet chosen to have children, do you think this impacts married women more seriously, like married women without kids?
I think it definitely does. I think this discrimination is present for all women of a certain age. I certainly think that, based on, I actually did, one thing James didn't mention in the introduction that perhaps I should have mentioned is that in law school, and then again I did another edition after law school, I did a book called Presumed Equal, What America's Top Women Lawyers Really Think About Their Firms. And I did that with a different co-author, but it was a survey of women at large law firms about these type of issues in large part. And, there are women who were advised to take off their wedding ring before the interview. There are perceptions by employers, that women of a certain age, if they are married, are going to have kids, are going to become a burden, they're going to leave, we don't want to train them, we don't want to give them opportunities, we don't want to mentor them because they're here for 2 years. It's not spoken, but that's the way they're treating those employees. So I think it's a huge concern. And I think, given the case law, women who experience that type of discrimination because of potential future pregnancies probably have a claim under the Pregnancy Discrimination Act and or, Title VII general gender claim. If they are denied opportunities and given less favorable terms and conditions based on the employer's belief that, yes, she's going to have a kid, we're not going to train her or put time into her. She's not going to get the type of opportunities that men do. And I think I gather from surveying women at large law firms, just to pick on that particular field, that it's very much a problem for married women without kids. Anything else? Wonderful questions, very interesting.
Thank you again, Elizabeth.
Thank you.